Welcome back to the deep dive. If you're thinking about starting a business here in Florida, it seems, well, almost too easy sometimes, right?
It really does.
All these online tools, state portals, it feels like you're just a few clicks away.
Uh-huh. But that feeling hides some pretty serious risks down the line.
Yeah, and that brings us to the question we're really digging into today. Which type of business, technically speaking, doesn't need a lawyer to get set up?
Right. And it's a great question because the short answer is super simple, but the reality, the long-term view, thinking about risk and proper planning, that's where it gets complicated and potentially expensive if you choose wrong.
Okay, so let's start there. The technical answer. In Florida, what's the one business structure you can basically just start? No lawyer, maybe no big state filing right off the bat.
That would be the sole proprietorship. It's kind of the default. If you just start doing business, selling things, or offering services under your own name, boom, you're a sole proprietor.
Just like that.
Pretty much. You haven't created a separate legal thing, a separate entity. You are the business. The business is you.
Okay, so if I, say, start Dave's Lawn Care just using my name, I'm technically set up, what about like local rules or paperwork?
Good point. While you don't file formation docs with the State Division of Corporations for the entity itself, you absolutely need to check local requirements.
Like city or county stuff.
Exactly. You'll likely need a local business tax receipt. Some places still call it an occupational license. And if you decide to operate under a different name, like Sunshine Lawns, instead of just Dave Smith.
A trade name?
Right, a fictitious name. You've got to register that with the state so people know who's actually behind Sunshine Lawns. But the entity itself, it just exists because you started working.
So, okay, that sounds incredibly simple, almost too simple. What's the catch? What's the big trade-off for that ease?
The trade-off is huge. Unlimited personal liability. That's the whole ballgame right there.
Right.
Meaning there's zero legal wall between your business finances and your personal finances. If the business racks up major debt, gets sued for breach of contract, or someone gets hurt because of your business activities,
They can come after my personal stuff.
they can come after your personal assets, your savings account, your car, potentially even your house, depending on exemptions. Everything you own personally is exposed.
Wow, okay, maybe for like a tiny weekend side hustle, that risk feels manageable. But I imagine as soon as things get even a little serious.
It gets serious fast. The minute you sign a commercial lease, hire your first employee or even a regular contractor, or start bringing in substantial revenue, that risk level just skyrockets.
Yeah, that sounds terrifying for most business owners.
It is, and that's precisely why most people who are serious about building a business quickly look past the sole proprietorship and start thinking about forming a limited liability company, an LLC.
Right, the LLC. And this is where that DIY temptation really kicks in, isn't it? Because our sources confirm, yeah, you can go online to the Florida Division of Corporations, fill out the form for articles of organization, pay the fee, and poof, you have an LLC.
You technically do. The state recognizes its existence.
But you're saying that filing, that's just step one, maybe even step zero.
It's really just the beginning. Think of the articles as getting, like, the permit to build the house. It doesn't build the house. The real structure, the rules for how it runs, the liability protection you think you're getting, how decisions are made, all of that lives inside the internal documents.
And the main one is?
The operating agreement. That is the absolute bedrock of a well-run LLC. And it's the thing that DIY formations, or using some generic online template, almost always messes up or completely ignores.
Okay, so the filing is the foundation, but the operating agreement is the actual house built on top. Let's get specific for our learners. What are the critical things that these online templates usually miss? The things that cause fights and cost a fortune later?
Okay, we see, I'd say 5 major gaps pretty consistently. First one, unclear ownership terms and voting rights.
Meaning who owns what percentage and who gets to decide things.
Exactly. If you've got, say, 2 members, 50-50, what happens if you disagree?
Yeah.
Who breaks the tie? Who has authority to sign contracts or hire people? Good templates force you to decide this up front. Bad ones just leave it vague.
And that vagueness turns into paralysis or a lawsuit the second there's real money or a real disagreement on the line.
Precisely. Second big gap, how profits and losses are allocated. Lots of templates just default to splitting everything based on ownership percentage.
Even if one partner put in way more cash or does way more work.
Right. Or maybe you want a different split for tax reasons. If your operating agreement doesn't clearly state how money actually gets divided, it creates huge problems, not just between partners, but also for your CPA trying to handle taxes correctly. You could end up paying tax on money you never even received.
Oof. Okay. Connects the legal doc directly to the bank account and the tax return. What's number 3?
Third, missing or weak transfer restrictions and buyout terms. What happens if one owner wants out? Or gets divorced? Or passes away?
Can they just sell their share to anyone? How do you figure out what it's worth?
Good questions. Without clear rules written down how ownership is valued, who has the right to buy it first, under what terms you can end up with unwanted partners, or get stuck in really expensive legal battles just trying to sort it out.
Makes sense. Protecting the existing owners. What's 4th?
Fourth is something people rarely think about until it's too late. Successor and incapacity planning. What if a key owner becomes disabled or mentally incapacitated? How does the business keep running? Who steps in? A good agreement plans for this.
Keeps the lights on even if something unexpected happens to an owner. Okay, and then the 5th gap. You mentioned taxes earlier.
Yeah, number 5 is often overlooking the crucial tax classification choices. See, an LLC is flexible. By default, it's taxed like a sole proprietorship if one owner, or partnership if multiple owners. But you can elect for it to be taxed as an S corporation or even a C corporation.
And each choice has different implications for taxes, salary, distributions.
Huge implications. Making the wrong choice or just sticking with the default without thinking or failing to file the right election paperwork properly with the IRS. It can cost you a lot in unnecessary taxes. The basic state filing doesn't address this at all.
Okay, so even the simple LLC needs a lot more thought than just filing the form. Let's move up the ladder. Corporations. Why does the need for legal help get even more critical here?
Well, corporations are just inherently more formal structures. They have more built-in requirements from day one. You absolutely need proper bylaws. You need documented shareholder agreements. You have to keep records of board meetings, issue stock certificates.
It's not just an internal agreement like the LLC's operating agreement.
It's much more rigid. And decisions about different classes of stock, voting rights, how dividends work, restrictions on selling shares, these things are complex and have big consequences for future investors or bringing in new leaders. Mistakes in setting up the corporate structure or maintaining the formalities are really expensive to fix later and can even risk piercing the corporate veil.
Losing that liability protection altogether.
Exactly.
Okay. What about partnerships? They sound simple too, right? Just 2 or more people deciding to do business together. Why are they flagged as potentially dangerous if you DIY it?
Because a general partnership can actually be formed by accident, just by behavior. 2 people start a venture together, maybe split profits. Boom, Florida law might say you formed a general partnership even with nothing in writing.
And the danger there is?
The default rules are harsh, the biggest danger. Each partner can be held personally liable for 100% of the business debts and obligations incurred by the other partner, even if you didn't know about it or approve it.
Wow, so my partner signs a crazy expensive lease I knew nothing about, and the landlord can sue me personally for the whole amount.
That's the default risk in a general partnership. It's called joint and several liability. So a written partnership agreement is absolutely critical to define who has authority to do what, how capital contributions work, how disputes are handled, and how partners can exit. It overrides those dangerous defaults.
So the agreement protects the partners from each other, essentially.
In many ways, yes, and clarifies things for everyone else.
And briefly, what about nonprofits? Sounds like double the complexity.
It really is. You've got 2 hurdles. First, you have to correctly form the nonprofit corporation under Florida state law. But then second, you have to navigate the whole process with the IRS to get federal tax exempt status, usually as a 501c3.
And both have strict rules.
Very strict. Your governing documents, your board structure, how you state your charitable purpose, everything has to line up perfectly between state requirements and IRS rules. A mistake can jeopardize your tax exemption, which is fundamental to operating as a nonprofit.
Okay, it's becoming really clear that the lawyer's job isn't just about filing a form. It's about designing the right structure for the specific business.
That's it, exactly. It's about thinking through how decisions get made, how money flows in and out, and, crucially, how risk is managed over the entire life of the business. A good lawyer looks at your actual goals, your industry, how you plan to grow.
And then builds a legal framework to support that.
Right. We've kind of synthesized the key areas where getting that legal counsel up front really pays off for Florida business owners. First, and maybe most importantly, personal asset protection. Choosing the right entity is step 1, but making sure it actually works with your insurance policies is step 2.
Good point about insurance coordination. Now, what else?
Second, getting clarity on ownership and control, especially if you have partners or investors. Who's in charge? How are votes counted? What happens in a deadlock? Defining that early prevents huge fights later.
Avoids those messy business divorces.
Hopefully. Third, aligning your legal structure with your tax strategy. Your lawyer and your CPA need to be on the same page about entity choice and tax elections, both for now and for the future, like a potential sale.
That coordination seems key. Often missed, I bet.
Very often. Fourth, setting up solid contracts and vendor terms. Good contacts up front mean fewer disputes, better cash flow, and less time wasted arguing later.
Proactive rather than reactive.
Exactly. Fifth, making sure your employment and contract agreements comply with Florida law. Labor laws are tricky and getting stricter. Getting this wrong leads to wage claims and penalties.
And finally, something about the long game.
Yes. Sixth is planning for the future. Succession and exit planning. Whether you plan to sell the business someday, pass it to family, or retire, having a plan in place makes the transition smoother and helps preserve the value you've built. It avoids forced decisions in a crisis.
And you mentioned Florida's Division of Corporations makes the initial filing seem easy.
Right. Their online portal, Sundiz, is quite efficient for the basic filing. But again, ease of filing does not equal completeness or correctness. It's just step one.
And things need to work together, right?
Wow.
Like the bank needing certain documents.
Absolutely. It's about coordination. Your bank will need specific corporate resolutions to open an account. Your insurance agent needs the right entity name and structure to issue the correct policy endorsements. Your CPA needs the operating agreement or bylaws to advise on taxes. If these pieces don't fit together because you just did a quick online filing, you have gaps, vulnerabilities.
Okay, let's bring it all home. If someone asked that initial question, which business type doesn't require an attorney to set up? The technical answer is
The sole proprietorship.
but. If the question is really, what's the best way to set up my business for long-term success, protection, and growth, the answer is clearly different.
Completely different. It's careful planning, clear internal agreements tailored to your situation, and a legal structure that matches your goals and your tolerance for risk. And that's almost always where experienced legal counsel becomes, well, not just helpful, but essential.
So for listeners wondering, okay, when should I really talk to a lawyer?
Yeah.
What are the trigger points?
I'd say definitely consult an attorney if you're bringing on a partner or taking investor money. Also, when you plan to hire employees or even regular independent contractors, signing a significant commercial lease or major supplier contract is another key moment.
Basically, when the stakes get higher.
Yeah, or if you anticipate significant revenue growth, are handling sensitive customer data, or starting to think about eventually selling or transferring the business. Get the right foundation in place before these things happen.
Makes sense. Get the protection set up before the storm hits, not during.
And that leads to the final thought we want to leave you with. The absolute best time to move away from a high-risk default structure like that sole proprietorship and into something protective like a properly formed LLC or corporation. It's early. When you first start taking on real risk, hiring people, signing leases, making consistent money.
Don't wait until there's a problem.
Exactly. Making the change when the business is small and simple is exponentially easier, cheaper, and safer than trying to clean up a mess after a lawsuit lands on your doorstep or a partnership dispute explodes. An ounce of prevention
It's worth way more than a pound of cure, especially in legal fees. So if you're ready to start your Florida business the right way, or maybe upgrade from a sole proprietorship, and you want that crucial coordination we talked about,
making sure the legal structure fits your actual business goals.
then we encourage you to connect with Barnes Walker. You can schedule a consultation with their experienced business law team. They serve clients all across the greater Manatee and Sarasota area, places like Bradenton, Palmetto, Parrish, Lakewood Ranch.
They really can help you navigate choosing the best entity, drafting those critical internal documents like operating agreements or bylaws, and making sure your legal, tax, and operational strategies are all working together from day one, protecting what you're building.
You can find them online at barneswalker.com. That's Barnes, WALKER.com, or give them a call at 941-778-7721.
And just a reminder, of course, everything we've discussed today is for general information and educational purposes.
Right. It's not personalized legal advice. For advice specific to your situation, you should definitely consult with a qualified attorney.
Thanks for diving deep with us today.
We'll catch you on the next episode.